clerk will open the court.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session.
Call now cause number PD-0108-20 and PD-0109-20. Bradley Jacobs Shumway versus the state of Texas. You may proceed.
May it please the court, Mr. Delmore. My name is Richard Canlis. I represent Bradley Shumway, the petitioner. This case is arising out of Montgomery County, Texas. We are here to discuss the proper application of the corpus delicti rule with an existing precedent and to review the Court of Appeals application of the corroboration requirement. This appeal is not about changing the rule, but working within an existing precedent, because in this particular case, the independent evidence does not show a sexual touching or a sexual contact. The independent evidence does not corroborate the corpus delicti of indecency with the child, and the independent evidence provides zero evidence that Mr. Shumway did anything inappropriate with the child. What is at stake is the long-standing corroboration requirement that ensures that there is some evidence to support a conviction, that there is some evidence outside of the confession to show that this crime occurred.
Counsel.
Yes, Your Honor.
Why should we keep the corpus delicti rule?
We should keep the corpus delicti rule because it is the most workable rule. One, it ensures that we provide some evidence that a crime occurred, so we can ensure that that someone is not wrongfully convicted on a false confession. And two, we've relied on this rule for 160 years.
Okay.
If counsel for defendant is confessing to the crime, why can't we consider that as evidence?
Well, the corpus delicti rule says that you can't consider it until you have independent evidence that shows the essential nature of the crime. So we shouldn't consider it because we want to have some independent evidence outside the confession. The public policy that this court had already addressed this issue in Miller in 2015. And in Miller, the court decided that we're going to keep the corpus delicti rule because there is a public policy. We're trying to achieve something to ensure that there is evidence of the crime outside of the confession.
Well, excuse me. We allow statements of other people without corroboration. The federal courts seem to have gotten along just fine without the corpus delicti rule, as have a whole lot of other states. And this may need to go the way of whalebone corsets and high button shoes and the race gesti rule and a lot of the things that we used to have that just don't make a heck of a lot of sense in light of everything else and the rest of evidence that we the rules of evidence that have existed a long time. This is not one that's just universally embraced. And it just seems like, it seems like to me, I just can't justify it rationally. Maybe there's something I'm missing.
Well, Judge, I disagree with the fact that there are other statements that are made that are not corroborated. I guess an accomplice witness testimony needs to be corroborated. The co-conspirator's testimony needs to be corroborated.
Well, that's a little different, I think, from a confession, because a confession, it's like the admissions of a party opponent or declarations against interest. It can't be more of a declaration against penal interest, which we've always said has has kind of the stamp of veracity on it. I mean, he wouldn't have made it unless it were true, because it's certainly not to his benefit. And basically, we've said, oh, no, you've got to have corroboration for it. Well, most other jurisdictions, English-speaking jurisdictions, don't require it.
Well, Judge, just to reiterate from my brief, review was not granted regarding to change the rule.
Well, we sometimes, we do a lot of things that that is not on that basis. But you're right. That is certainly something to consider.
Understood.
And I'm not going to be around that long to make sure that my wish to do away with it is good. He's
not dying. He's not dying. He's not saying that he's dying.
Yeah,
no,
and
I'm not going
Miller-
to be on the wrong side of the dirt, I hope, anytime soon.
And Miller did have some independent evidence.
That's correct. Miller did have some independent evidence. Miller, there was independent evidence of semen on one of the transactions, and there was an exception made for a closely related exception, meaning if you had the corpus delicti of one of the charged crimes, you could use it to corroborate the others. But to go back to Judge Kiesler's, question, there is a public policy behind the corroboration requirement, and that public policy is to make sure that there is some evidence of a crime, because it doesn't just show up on its own. At some point, the people in charge determined that there were people that were giving false confessions, and that people were getting convicted because of these false confessions, and because of what happened in England, where people would just say things because of force, and then all of a sudden there's no evidence that they did the crime, and then they're convicted.
Counsel, why isn't that concern adequately dealt with by the application of our Jackson versus Virginia sufficiency rule?
Well, in Jackson, it's my understanding that there's any evidence in the record to support it. Well, under the corpus delicti rule, by the case law, you're not supposed to use the conviction at all unless you have some corroborating evidence. You have to have some independent evidence of the crime. And that's what we're trying to make sure of.
Well, I mean,
Aren't there some, I'm
Sorry.
sorry, Kevin, go ahead.
no, I'm sorry.
Go ahead.
I was just wondering whether, can that not be something that could be argued to a jury, that there's just not sufficient evidence presented to that jury that would allow any of them acting rationally to conclude that a crime actually occurred? Couldn't that argument just be made to the jury?
It could, but the purpose of the rule is an evidentiary sufficiency rule. Instead of the last.
Well, aren't there some provisions to allow you to get at the reliability of the confession besides having the corpus delicti rule? I'm pretty sure trial courts rule on voluntariness of confessions all the time.
That is true. That is true, Your Honor. But if you don't have independent evidence of the crime, you don't have there's no way to verify that the crime actually occurred. You could have a person that confesses to a murder, or you can have a straw man. You could have a person with a lot of means go to someone that's poor, pay them to confess to the crime, and there's no independent evidence to match the crime, and they get convicted of this.
Sure, counsel. I understand what you're saying. I understand where you're getting, which we have a lot of cases there where there's been a false conviction, and that because new evidence comes to light, that casts doubt upon that false conviction. So corpus delicti would seem on the front end to prevent that kind of situation. I certainly see that. I wanted to ask, though, there was some mention of the accomplice witness statute. Is there any statute that has been created that undermines the application of the corpus delicti rule? Because corpus delicti is common law, and we have statutes that when we've said in cases that these statutes are meant to replace the common law. Is there anything like that suggests a statute that was meant to replace or undermine or limit the corpus delicti rule that you know of?
I am not aware of anything like that, Your Honor.
All right.
What would you say, Mr. Canlis, about the state's argument that the requirements of the corpus delicti rule have sort of evolved over time, and that there's really a difference in the definition of it, say 100 years ago versus 10 or 15 years ago?
Well, I think the wording of what we call the corroboration requirement has evolved. It used to be the independent evidence needs to show evidence of the corpus delicti. Then it slightly changed to it needs to be independent evidence that the crime actually occurred. And after 2002 in Salazar, which was indeed the trial case, the wording changed to, it needs to show the essential nature of the charged crime, which in this case is sexual touching or a sexual contact. So overall, it's the same thing, that there needs to be independent evidence which shows the crime occurred. There needs some evidence that links it to that.
Well, doesn't the defendant's behavior, the appellant's behavior in this case, supply that?
No, Your Honor. The appellant's behavior, I'm assuming that you're referring to what was confirmed by the wife's testimony about,
Correct.
About Mr. Shumway being alone in the house by himself, and she confirmed that she and her daughter were outside, and that his comments about his motivation, about his and about the opportunity. Well,
and then the opportunity, and then his behavior after that, the way he acted with as though he had a guilty conscience.
Understood. Now, this court has already addressed this type of evidence in Hacker, which I believe is in 2013. Evidence of motivation, opportunity, presence, state of mind of the defendant are not evidence of actual prohibited conduct or evidence of sexual contact. They are connectors of that evidence once you already have some type of evidence of that.
And we have that with his confession, correct?
No, Your Honor, because under the corpus electi rule, you're not even to consider, turn the page and review the actual confession until you have first met the threshold question of providing some evidence of the essential nature of the crime.
Let's just talk just for a moment. I just come back to this. If old William Witness over here says that an offense happened and there's no other evidence of it, that's perfectly okay. But if Dan defendant does the same thing and it's a declaration against interest, which adds more reason for it to be, true, that's not good. And if another a person over here says that it happened, but that's the only evidence. But I mean, it covers all the elements of a particular offense. It's allowed, but just because it is the defendant who's on trial, it's not allowed. That just doesn't make a whole lot of sense.
Well, if you're furthering the public policy of making sure that people don't confess to crimes they did not commit, it does make sense because you're requiring that there be some evidence of the crime.
But don't we have other safeguards on this? The fact that, the law says that it can't be coerced, that you can't just hold somebody without food or things like, just one thing after another that are constitutionally accepted. But really, when you get down to it, when the federal courts and the Supreme Court of the United States, there's no requirement of any corpus delicti rule, it's just real hard to justify keeping it.
Understood, Judge, but the coercion part that you're referring to doesn't take into account people that have mental health issues who just say things to say things. It doesn't take into account the straw man.
And can't.
But the evidence there can be evidence of mental health issues. There can be evidence that's shown to the jury, about that this was a coerced confession or this was a confession as a result of mental health issues and there's no other evidence to support it. That can all be shown to a jury and argued to a jury.
Understood, Judge. But once again, you don't have the independent evidence there. There's nothing there.
But that's what you point out to a jury.
Correct.
Counsel,
you don't have it with a single.
Sorry.
Go ahead.
Oh, I was just going to say, if we side with you or we take your we side with you on this case, doesn't that sort of create the perfect crime for defendants to engage us? There would be no way to corroborate absent someone accidentally walking in. But you know, this makes it almost impossible because there really wouldn't ever be a way to corroborate this kind of thing.
Well, I disagree, Judge Newell. The reason why I say that is this. The threshold question of is there any evidence, independent evidence to show the crime occurred is very, very low. It has to just be some evidence. And two, in the modern day world where everything is recorded and where law enforcement has the technology to obtain information that you typed on your computer, recordings off the street, recordings off your phone, your text messages, your email, a whole wealth of information is available to indicate that maybe you did something here just off of that.
But
Also,
when you're dealing with children that are 3 or 4 months old, and it's the defendant and a 3-month-old child in a nursery situation, the evidence is going to be based mostly on what the defendant decides his guilty conscience can't stand, and he confesses.
Yeah, if it was a perfect crime, though, the defendant just wouldn't confess if he wanted to commit a perfect crime.
Right.
Well,
So-
and this kind of offense, it doesn't happen on the 50-yard line at the Super Bowl with everybody looking on. This is the kind of offense that does happen in private. And so,
Yeah,
I
but
mean,
the
you have
corpus-
that added to it.
Yeah, but the corpus delicti rule only applies when the defendant confesses. If he doesn't confess, then all these sexual assaults of young children, he's not going to get convicted anyway.
No.
So okay. Counsel, did you want to finish up your argument?
At this point, Judge, I'm going to reserve the rest of my time for rebuttal.
Can I ask you one question first? I have one question for you. In this case, there was actually 2 confessions. Why can't the second corroborate the first?
Well, first of all, Judge, like I said before, the corpus delicti rule requires independent evidence that the crime actually occurred. You shouldn't
But isn't the second confession independent evidence that a crime actually occurred? He said he did it.
Not according to the rule, because it's an extrajudicial confession, which the rule requires that there be independent evidence to show that first. Now,
Okay.
the case that was referred to in the state's brief out of Kansas is a reliability of confession rule-based state, unlike ours. We rejected that particular rule in 2015 in Miller. But just because, once again, in terms of evidence of the crime, just because you say something twice doesn't make it true.
Counsel, how much time did you intend to reserve for rebuttal?
5.
5 minutes? Okay, well, you can have 4 because you're more than that out of time. Thank you, counsel.
May it please the court. My name is Bill Delmore, and I'm representing the state of Texas in the appeal of this Shumway case. Judging by the questions that the court had for Mr. Canlis, I feel like we may have missed the boat a little bit by failing to ask the court to completely abrogate the corpus delicti rule. I didn't want to get greedy, to be honest with you. The court had previously declined to do that and instead made an exception. So we made a tactical decision that it would be in our best interest to simply ask the court to make another exception to the corpus delicti rule for cases involving cases involving a trustworthy confession to an offense involving a nonverbal victim who's incapable of outcry, which is exactly what the Supreme Court of Kansas did in the State versus Dern case cited in our brief. So we ask that the court strongly consider at least going that far, if not farther. We stated I'm
So,
sorry.
so then you agree then that without this exception, then this doesn't satisfy the corpus delicti rule?
No, I don't agree with that, Your Honor, because
Okay.
I think we've gotten off track in applying the corpus delicti rule. And that historically, over 100 years of case law, this court has allowed the use of the confession to aid in proof of the corpus delicti. And that rule dates back to the Cugat case from 1878, in which the court specifically addressed this issue of whether the evidence of corpus delicti has to be completely independent of the confession, or whether you can consider the confession in aid of proof of the corpus delicti. And the court held very specifically that the confession is not to be excluded, but is to be taken in connection with the other facts and circumstances. In that case, Cugat was described as the leading case on corpus delicti law for over 100 years. And by my count, it's been cited by this court for that proposition at least 48 times, not counting dissenting opinions.
So in other words, you don't even think that you believe that that the state wins even with the corpus delicti rule in its current form?
Yes, Your Honor. I think the Court of Appeals got it right and found that a well-corroborated confession can be used to aid in proof of the corpus delicti. And that's what happened in this case.
But don't you think that Miller and Hacker deviated somewhat from that older tradition and statement of the corpus delicti rule?
They certainly did, yes, Your Honor. I think that if the court retains the corpus delicti rule, and as I stated in footnote 1 of our brief, we would applaud the complete abrogation of the rule, don't get me wrong. But if it were to be retained in its present form, I think the main issue here is harmonizing this long-standing rule from Cugat that you may consider the confession with the more recent statements that originated in Salazar, I believe, in 2002, which really don't have the kind of force that a century, 48 citations has in terms of deciding what is the established common law of the state of Texas. Salazar, the issue in Salazar wasn't whether you can use the corpus delicti in aid of, the issue wasn't whether you could use the confession in aid of proof of the corpus delicti. It was instead, it was a completely different issue, and I don't recall exactly what it was. Oh, it was whether the corpus delicti had to establish the exact manner and means that's alleged in the indictment. And so the court's emphasis was, no, you don't have to show the exact manner and means through the corpus delicti. It's sufficient for you to show the essential nature of the offense. So as long as the corpus delicti shows some sort of sexual touching, it doesn't matter that the extraneous or independent evidence showed a different form of touching than what was alleged in the indictment. So that was the focus in Salazar, and that's where we came up with the phrase essential nature. Since then, that statement of law from Salazar has only been cited by the court in 5 decisions, including Salazar, or 5 published decisions, and 4 of them had nothing to do with this issue. So it was just dicta in those 4 cases.
Mr. Gilmore, I don't want to take you off your train of thought, but I wanted to ask about whether you heard Judge Walker's question to opposing counsel and about whether a confession can corroborate another, like a subsequent confession can corroborate an initial confession, and whether you are aware of any opinions from this court or any other court for that matter that might give support or detriment to that idea.
I looked really hard for some Texas case law that would speak to that, Your Honor, and I didn't find any. I did find a case from another jurisdiction. It is cited in our brief, and it found that you cannot generally use one non-judicial statement to corroborate another non-judicial confession. On the other hand, we found a case from Kansas again that said that you can use the fact that the defendant made multiple consistent statements as some evidence or corroboration of his primary confession, which in this case was to the spouse. So the answer is no, nothing from Texas. There's some out-of-state case laws saying you can't corroborate a confession with another confession. And we found some case laws saying that it does contribute to some incremental level to the corroboration and the trustworthiness of the primary confession. Because Salazar was addressing a different issue in its recent case law, and it has not been used in the decision in subsequent cases since 2002, we would ask that the court reaffirm the Cugat rule that allows the use of the confession to aid in establishment of the corpus delicti, and at the very least modify that statement of law from Salazar.
Counsel?
Yes.
In Cugat's, there was actually blood in the carriage or whatever. Like, what evidence do we have here that does corroborate? What would you point to that corroborates the confession in this case?
There was a lot of corroboration, Your Honor, of the details of the defendant's description of how the offense occurred that day. The corroboration went to motive, opportunity, and consciousness of guilt. We corroborated the presence and the identity of the child that he was caring for on a particular date, his opportunity to commit the offense while he was alone with the child, while the wife was outside speaking with the daughter. We corroborated his resentment of his spouse for leaving to have lunch with her friends while he had to care for the children, which he explained was part of his motivation for committing the offense. We corroborated the fact that the spouse took the victim's shorts off because they were too small, leaving the child to run around in a diaper, which the appellant also mentioned as in regard to his motive for molesting the child. We corroborated the fact that he was fasting afterwards and went to visit the bishop over a problem that he had, which evidences a consciousness of guilt. And then finally, his consistent confession to the bishop certainly makes it more likely that his primary confession to his spouse was true and accurate. So based on all that, I mean, it was kind of a slam dunk for the state in terms of convincing a jury that he was guilty beyond a reasonable doubt. I mean, this had to be one of the most trustworthy confessions that the court has ever heard about, because it wasn't obtained through any type of coercion or persuasion by law enforcement. It was totally the product of the appellant's religious motivation and his sense of guilt. And it was made voluntarily without being elicited in any way. And it was made on multiple occasions.
What do you say about defense's argument, though, that everything that you point to as far as corroboration doesn't go to show that the crime occurred, it goes to show the reliability of the confession?
I think that Mr. Canlis is correct in saying that none of the corroborating evidence tended to establish an actual sexual touching of the child, which is why we're asking you to modify that statement of law from Salazar and return to 100 years of common law as established by the line of cases resulting from Cugat.
Yeah, and if all the surrounding circumstances show that the statement is correct, and the statement says that he committed the offense, then why does it not establish that the offense occurred if he said it is and it's reliable?
Yeah, we absolutely feel that it does, yes. I just felt like our hands were tied a little bit by this court's decision in Miller.
Well, yeah.
In which the court said, we're not going to adopt the federal trustworthiness standard for a confession. So absolutely, the corroborating evidence tends to show that this confession was accurate. It was true and it was reliable.
Are Miller and Hacker inconsistent with Cugat?
Yes, Your Honor. I think they are. I don't think they can both be harmonized. Well, I think they can be harmonized, but as they presently have been stated by the court, I don't think they're consistent.
So how do you harmonize them?
I think that you reaffirm the Cugat rule and you modify the rule from Salazar to say that there must be independent corroborating evidence that when considered alone or in connection with the confession tends to show the essential nature of the offense.
But isn't that what happened in Miller? There was a confession and there was independent evidence.
In Miller, if I recall, Judge, there was independent evidence of some of the sexual acts, but not all. There was one in which there was no physical evidence that corroborated the confession or supported the confession. And that's why the court, instead of reversing that case, identified an exception for closely related offenses.
Mr. Dahmer.
And it was the court's, I'm sorry, Ron.
No, go ahead.
It was the court's recognition of an exception for closely related offenses in Miller that suggested to us that the court might be amenable to making another exception for a trustworthy confession to an offense involving a nonverbal victim.
Well, as to it would be a whole lot cleaner, I would think, to just go ahead and bite the bullet and disavow the corpus delicti rule. But I think the way you do that is, there are two reasons to not follow precedent. One is if it is unworkable, and then the second one is that if it is logically, that it's rationally flawed. And it seems to me, you got plenty of support in academic writing and certainly in federal precedent to show that really it doesn't make much sense where just a normal person who has no indicia of reliability, I mean, independent reliability in and of itself that says that an offense takes place, and you have a criminal or a defendant saying that it does, and it's, and you have the civil things are admissions and declarations of against interest, which said, corroborate the verity of what's concluded, and it just doesn't make much sense where you have something where there's no indicia of that, saying, well, yeah, that's sufficient. If the jury believes it, let the jury hear it. And what we're talking about here is excluding evidence just altogether, rather than letting the jury decide whether or not it's true. So anyway, it just makes sense. But I think to me, that's the cleanest way to do it, but that's not saying that that'll happen, but I won't be here anyway.
Judge Yeri, did you have a question?
Not at this point, thanks.
I do have a question.
Well, I do too. I was just going to defer to Judge Yeri. So since we're talking about whether the corpus delicti rule is a good idea at all, is this a case where it would be fair to address that issue, given that neither you nor opposing counsel has briefed it?
I think it would be, Your Honor, except that we asked that the court cut a very large exception from the corpus delicti rule. And we preserved that issue in the Court of Appeals. The Court of Appeals didn't address it. So I'm not entirely clear on whether, if you wanted to make an exception to the corpus delicti rule, or whether you abolish the rule in its entirety, whether you would remand to the Court of Appeals to initially address that question. You don't always do that. Sometimes the court finds that in the interest of judicial economy, it will just go ahead and resolve an issue that was preserved in the court below, but not decided by the Court of Appeals.
Okay, thank you. Judge Walker wants to get a question in.
Okay, my question is, if the majority of the court decides to keep the corpus delicti rule intact as it is and follow our Miller decision, which I think was only 5 years ago, how could what elements would we put in another exception if we chose to create this exception that would not, that would still be congruent with the holding in Miller?
Well, first, Miller just made an exception, and it doesn't preclude the court from making another exception. And second, I think what we're asking is that the court pretty much follow the example of the Supreme Court of Kansas in State versus Dern. And the elements of this new exception would be that it's a trustworthy confession, and it's to an offense committed against a nonverbal victim who's incapable of outcry, because those are the cases that seem most likely to cause a really terrible result, a really unjust result.
Okay, and my question then is, when I read the Dern opinion, it really didn't seem to clearly include that second element, the one that it's a nonverbal individual that's a victim. Are you suggesting that we do make that an element clearly if we do an exception?
I think so, Your Honor, and I think that is in the Dern formulation. But just to be clear, I certainly am not arguing against the court's complete abrogation of the rule, which we encouraged in footnote 1 of our brief. And we noted that stare decisis is important, but it's not controlling if the court finds that a precedent was poorly reasoned or unworkable. And if you keep having to make exceptions to the rule, then maybe it is poorly reasoned and unworkable.
Are you suggesting that
wait,
Miller
excuse
is
me,
poorly reasoned or unworkable?
We're grateful for Miller. Miller was decided in the state's favor. I just was very disappointed that it didn't go further and abrogate the rule in its entirety. Miller was a pretty limited decision with regard to the closely related offense exception.
Judge Keel, did you have a question?
I did. I just wanted to ask, if we go back to the CUGAT formulation of the corpus delicti rule, we really don't need to make another exception. And I mean, it's a different formulation altogether, isn't it?
Yes, Your Honor. If you reaffirm the CUGAT rule, which was very long-standing, and modify that statement of law from Salazar, then this case gets affirmed based on the Court of Appeals analysis, and it would not be necessary to make another exception. I agree.
But yet again, you're saying that you squarely have asked us to address abrogation of this rule? Because it would be nice if it was presented to us so that we could not have to perhaps make an exception and we could directly address it.
Gosh, I wish y'all had not discouraged me from doing that in your Miller decision, but we did state in footnote 1 that we would welcome and applaud the complete abrogation of the corpus delicti rule, but we weren't asking for it at this time because just 5 years ago, you very clearly declined to do that.
Well, how dare you rely on something we did?
I'm starting to wish I hadn't, Judge.
Well, I'm kind of liking the Miller opinion myself. Just since I wrote it.
Yes.
Yeah.
But the thing is, the truth was you felt bound by precedent, but now you've become all of a sudden enlightened.
Yes, Your
That's
Honor.
a great thing.
Counsel, your time is up. Did you have anything else to say?
No, I think that's all I have, Your Honor. Thank you very much.
Okay, thank you.
Well, Your Honor, I disagree with Mr. Delmore's, description of the CUDAT rule. The CUDAT rule, back when CUDAT came out, there was already a corroboration requirement that there had to be some evidence. And that's always been the rule. There had to have been some evidence, even if it was small, to show that the crime occurred. It was just more strict than it is now. I disagree with Mr. Delmore in terms of Salazar making it harder. Salazar actually made it easier because now it's just you have to show some independent evidence that the crime occurred or the essential nature of the crime. You don't have to meet the hard, fast rules of the corpus delicti. It actually relaxed the rules. The corroboration requirement is a threshold question. The threshold question is there any evidence that tends to establish the essential nature of the crime? Any evidence like of a sexual touching or a sexual contact. And the law has always been during this time that once you have that, does it make a difference? Does this evidence make it more probable than not that the crime occurred than without the evidence? And that's when, if the answer is yes, that's when you can use the confession. The CUDAT rule is essentially saying this: if you meet the threshold question of some evidence, and it makes it more probable that the crime occurred, which is the corroboration, then you can use the confession to aid the proof of the total crime. That's what CUDAT stands for.
Mr. Canlis,
Yes, Your Honor.
in light of the footnote 1 in the state's brief that I'm sure you received and were aware of, would it be unfair of the court to move forward and address whether one way or another, whether it ought to completely abrogate the corpus delicti rule in this case? Is there some reason why we should not do that in light of the fact that the state made that argument in footnote 1 of their brief?
Yes, Sean, I do think it is unfair. because we requested review on the 4 issues that were presented. The court granted review on those 4 specific issues. Mr. Delmore did not request review, and this court did not sua sponte demand review on the particular issue to modify the rule or to get rid of the rule. So we are on. It's not addressed in the brief. It's not. So yes, I think it is unfair.
But you would have, if you read footnote 1 of the state's brief, would you not have had an opportunity to file a reply brief and address that issue?
Correct, Your Honor. And I did file a reply brief to the extent that review wasn't granted on that particular issue.
So that's in your reply brief, you're saying?
Correct. That review wasn't granted to modify or change the corpus electi rule.
Thank you.
Now, in terms of the rule not being workable, it's absolutely workable because the threshold question protects the public policy of making sure we don't have people convicted for false confessions without any evidence. The standard is very, very low. It can be semen somewhere. It could be an inappropriate touching that someone thought was not proper when a child is around. It doesn't take.
Excuse me, counsel. Would you agree that the whole purpose of the corpus delicti rule, in a broad sense, is just to ensure that justice is done in our courts?
It's to ensure that we have a conviction without evidence in terms of a false confession.
But isn't that really just upholding fundamental ideas of justice?
Yes, Your Honor, I agree with that.
And isn't the facts of this particular case, doesn't it present a counter idea of justice based on the facts of this case that would just make anybody that reads the facts realize that we either need another exception or something to keep these kind of individuals who's confessed twice to terrible crimes against a very young child that cannot outcry, that we do need to do something if we're going to uphold the notions of justice?
Well, I disagree, Judge. The reason why I disagree is that in the modern day world, there's a footprint of everything. Everything's recorded. Everything we do is there. Science has developed where we can obtain evidence that we couldn't see before during Kudat's time. We could find evidence. We could find semen. We could find searches regarding child pornography that were erased. We can find communications that people have made regarding that would confirm this type of conduct. Rule.
No, please carry on. I'm sorry to interrupt you. Let me just ask the question that was on my mind when I unfortunately interrupted your thought process. And that is, you suggested a moment ago that for in terms of your thinking about the reasons for the corpus delicti rule, reason is to make sure that we don't have convictions based upon false confessions. And I'm wondering what you think about cases in which there are confessions, but there are also assurances that of the trustworthiness of those confessions, so that you don't really have so much of a concern about the falsity of that confession that might exist under other circumstances, like where someone is being, unduly pressured by law enforcement or some other circumstance that's going on around them.
Well, Your Honor, in this particular case, what they're really doing is they're confirming facts that aren't relevant to whether or not the crime occurred. Meaning that he was inside the house, the wife was outside the house. That's just one example. That doesn't make the actual act more trustworthy, meaning the crime more trustworthy. It's just confirming a secondary fact that's irrelevant to whether or not the crime occurred.
But my question isn't really whether there is evidence in this record, because we can make that determination about whether there is evidence to sort of guarantee trustworthiness. But what about the issue about whether if we do find that there is evidence of trustworthiness, for example, if we were to rely upon something like well, let's just say if we were to find evidence of trustworthiness, then couldn't that be something that might support the acceptance of the contents of the confession?
If you were, possibly, the U.S. Supreme Court follows that rule, but this court, as far back as in Gribble, already determined that support for the credibility of the confession is not enough, that you have to have outside evidence which shows that can confirm that the crime occurred. Some evidence.
Okay, counsel, I believe your time is up. Did you want to wind up your comments?
Yes, sure. Real briefly. The precedent is the foundation of our common law. And when defendants make the decision to plea or to go to trial, they must make an informed decision. And the law as we have it, as the corpus delicti rule is in place, it gives defendants the ability to make an informed decision on whether or not to go to trial because they can see if there's any independent evidence of the crime. The Court of Appeals opinion now makes it unclear. The corroboration requirement serves a great purpose of protecting against false confessions. It serves a great purpose in showing that there is some evidence to support the conviction outside of the confession. We're asking this court to find the evidence legally insufficient because there is no independence of a sexual contact or sexual touching or of the corpus delicti at all. Mr. Shumway requests that you reverse the Court of Appeals and enter an order of acquittal per Brown v. State. Thank you.
Thank you, counsel. The case is submitted and the court stands in recess. The clerk will adjourn the court.
Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals now stands recessed, subject to the call of the presiding judge.